Fani Willis in Georgia is now moving to revoke this guy's bond. Of course, has been charged in the RICO case, prosecuted by Fani Willis. Donald Trump is another co-defendant, but Harrison Floyd has already been serving jail, has already been in jail, and now Fani wants to send him back. And so we're going to go through this motion to revoke Harrison Floyd's bond, which is something that Fani just submitted, and it comes after Harrison Floyd was posting some stuff on X. He was saying that Fani has a pretty bad case, and some of the witnesses in the case are not so hot, and she says, uh-oh, those posts amount to witness tampering. And so here's what the motion looks like. Out of Fulton County, it is state of Georgia versus Donald Trump and many other people, but this specifically is about this guy, Harrison William Prescott Floyd. There's the name. So many co-defendants here, I couldn't even find them. And so you can see this is Fani's motion to revoke the bond concerning Harrison Floyd. And here's what Fani says. She's very upset. Wants to put him back in jail. Now, he was already in jail the first time because of a bond problem, right? He was there showing up and didn't have an attorney, and the judge held him in bond until he posted bond, and now he's out. So now she says it's time for him to go back. Says here, Fani requests that the court enter an order revoking the bond that was already previously granted to Harrison Floyd, saying here that the Fulton County grand jury charged him with crimes, and on August 29th, 5 days after he surrendered, so he went and surrendered August 24th, and then was released from custody August 29th, the court entered a consent bond order, and they set bail, and he said that he has to do certain things. As terms of his release, they said he shall perform no act to intimidate any person known to him or to be a co-defendant or a witness in this case, saying he shall not communicate in any way, either directly or indirectly, with the facts of the case, and not communicate any way, directly or indirectly, with any person known to him to be a witness in this case except through counsel. Okay, so these are the release conditions that the judge imposed when they released him from custody. Now, since his release from custody, they say the defendant has engaged in numerous intentional and flagrant violations of release, saying that since November 1st, the defendant has publicly tweeted, and they're called X's now, Fani, get it right. From the X account, it's called X, hello, at HW_Floyd, which I'm following, you might want to follow as well, in an effort to intimidate co-defendants and witnesses, to communicate directly and indirectly with co-defendants and witnesses, and to otherwise obstruct the administration of justice. Now, she definitely does not want him, talking about this. So the defendant's Twitter account has 25,000 followers who can view his public tweets, and I have done that myself. Now, on November 1st, the defendant tweeted the following to a witness. Brad Raffensperger also sent this one to Gabriel Sterling and tagged their Twitter accounts. He's actually tagging them, which constitutes an act to intimidate known witnesses and direct communication with known witnesses about the facts of the case in violation of conditions of release. Let's see what he's tagging him to do. Here's what he says. David Goldiner posted this on X, says, hey, responding to H.W. Floyd, says, get some decent legal advice before you end up spending 20 years in prison for someone who could care less about you. And he said, passing this along to the Secretary of State and to Gabriel Sterling, says, should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fani Willis, or all of the above, right? So he's actually talking kind of about the case and maybe them as a witness. Now, on November 6th, they say he participated in a video recorded and widely disseminated interview on a conservative daily podcast. During the interview, the defendant discussed the facts of the case, and he communicated indirectly to co-defendant and witness Jenna Ellis. Okay, so he discussed her guilty plea in violation of his release conditions, saying that the defendant stated the following, said President Trump was underserved by people like her, Jenna. People who would go into the Oval Office and tell him one thing, and then behind his back, they would do another. Now, I'm not a lawyer, he says. I'm not a Harvard JD, but guess who is? Jenna Ellis, right? She literally, if she truly believed everything that she was saying, she could have defended her own self. She didn't need $250,000 of people's hard-earned money to be raised offline, And it doesn't take $250,000 to accept a plea deal either, or to deny one, okay? She just showed us who she really is. Interesting take there, Harrison. Now, he continues. Now, in addition, and Fani definitely does not want that to go out there, of course. Now, in addition to participating in any of the above referenced interviews on November 6th, the defendant also tweeted the following link to the interview to amplify its viewership. Oh my gosh. You definitely don't want to go watch this, do you? This might be something interesting to watch after this show's over, but I don't know. Harrison Floyd says, thanks for having me on. And here, what happened here? Real Joel Altman had a conversation about David Clements. Okay, looks like 3,000 views. It probably could be more than that now that Fani wants to ban it. I mean, if you ban these things, people want to know more about it is all. So on November 7th, the defendant also tweeted the following to a witness called Brad Raffensperger, who's still the Secretary of State over there, okay? Like, he still is in government. Can you not talk to him? And Gabriel Sterling, and he tagged their Twitter accounts, which they say constituted an act to intimidate known witnesses and direct communication with known witnesses about the facts of the case. And so Fani says that Harrison needs to go to jail for posting about the case. Now, on November 7th, the defendant tweeted to the following witnesses: Brad Raffensperger, Gabriel Sterling, and he tagged their Twitter accounts. Again, witness intimidation. Brooklyn Flowers says to Floyd, you're broke and going to waste money and putting forth, or maybe he's talking to Raffensperger. Oh no, he's talking to Floyd. This guy says, as if those 5 days you spent in jail wasn't enough. We're going to lock you up. Can't wait to lock you up in Georgia. They're getting into it. You're going to jail, buddy. My partisan prosecutor is going after you. Harrison said, Black American Dems want the black Trump guy to tell on racist white Republicans, but only if it's President Trump. LOL. Look, the truth is the Georgia Secretary of State and Gabriel Sterling are the pieces of poop emoji that you should be mad at. Make elections fair again. Thumbs up. Not a bad point there, Harrison. Here's another one. On November 8th, the defendant tweeted to the witness Brad Raffensperger and he tagged his Twitter account, which is an act of witness intimidation. Anthony Scott, who is this, says Senior VP of Customer Operations of Election Systems and Software, the company responsible for PA votes flipping, says it was human error that someone from our team, quote, programmed the election. Harrison Floyd reposted that, said it's over. Georgia Secretary of State Raffensperger needs to call his lawyer. He's about to go through some things. Exclamation point, hashtag fraud, hashtag cheating, hashtag election interference. Harrison continues. On November 13th, he also tweeted the following to co-defendant and witness Jenna Ellis and to Dan Scavino, who has not been charged with anything, and tagged their Twitter accounts, which constituted an act to intimidate a known co-defendant and a witness and direct communication. So Midas Touch, which is a major lib account, it says during her proffer session before Georgia prosecutors, Jenna Ellis said a statement, said the boss is not going to leave during a drunk White House Christmas party that nobody cares about. And Trump did leave, so it's like totally irrelevant. What are you talking about? He's not going to leave? He did leave. What? Okay. They packed up. It was like a whole thing. So they left. So Harrison responded to Jenna. He says, wow, Jenna, you're a whole mess, girl. So you didn't stop at stealing people's hard-earned money for your defense. You're also lying on Dan Scavino. This is probably the one that did it. I guess they don't teach ethics at Harvard Law anymore. Hashtag give back the money. I told you, he's a good follow, man. HW_Floyd. So, you're also lying on Dan Scavino. We haven't heard from Dan Scavino, but it sounds like even if he said something like that, like they left. And we were talking about this on our locals after party yesterday. Maybe he's just saying we're not going to leave the party because the artichoke dip is out of this world, man. It's crazy. Have you had it? Go get some. Trust me. No, I know you don't like it. Just go try some. No, it doesn't taste like it. Just go try it. We are just going to stay in power. He's like, I'm not leaving this party, man. I got endless artichoke dip. So on November 17th, he also tweeted the following about co-defendants and witnesses Jenna Ellis and Sidney Powell, which constituted an act to intimidate witnesses. He posted this from ABC News. They were sharing Sidney Powell's tweet. This guy, Harrison, who's under indictment by Fani, says there is literally nothing here but name calling and speculation, right? Nothing here. These are the ones that did it, right? He was going off and they didn't care all that much until he starts posting about these. He's right. We were watching these. We're like, there's nothing. This is it. This is the big reveal. Like all of these proffers were supposed to be the end of Trump. They got smoke and plea deals because they were going to get him on the back end. And this is it? Even Harrison Floyd, he's been charged with a crime. He's like, there's nothing here. Leaking Jenna Ellis and Sidney Powell, the proffer, is nothing more than an attempt at tainting the jury pool. Fulton County is corrupt. When is GA leadership going to step up? Well, no, they're not going to. It turns out the defense leaked it, but there's nothing else in there. It sounds like, right? And I think the defense wanted to set the record straight. They're making these plea deals and proffers like there's something there. There's nothing there. The defense is like, look, it ain't there, right? Fani ain't got nothing. So they say here, Harrison keeps Xing, says the defendant X'd. Come on, Fani. The following about Ruby Freeman, which is also a witness who's now intimidated. Harrison Floyd posted this, and I'm not real familiar with this story, but Fani put it in her motion. Here's what she says. She says, Harrison posted this. If we are sharing and leaking videos today, like I said from the start, Ruby Freeman was terrified and wouldn't talk to anyone white. That's weird. Why? Because racism and political terrorism in Georgia is still very real. This is a cover-up, and Fulton County is corrupt. And so he shared this video, probably still up on his X account, and go watch it over there when you go and subscribe. Now, approximately 1 hour later, they say that Harrison posted a comment that stated, so this begs the question, if Ruby Freeman didn't trust white people to help her, what did she say to the black people that offered to help her? I'll wait for you to get your popcorn. This constituted an act known to intimidate a witness. Now, here's another one. They say on November 14th, he also tweeted the following, saying, yesterday, the Fulton County DA's office leaked proffer videos, and now they're trying to blame my team in order to get a protective order. Now, this is partially true, right? They did try to blame his team and they played it hard. Now, Harrison at the time did not know that it came from another defense attorney, right? So he was presuming that they did it, which was a pretty good presumption at the time. Now, we were all kind of caught off guard by the defense leaking it, but I get it, because there was nothing there. The only blind spot that we had was there anything else there? Like, there was nothing in the videos we saw, but the full proffer is much longer than that. So we just saw, 2.5 minutes total between the two videos. So we didn't know if it was going to be like a bigger leak, does Fani have more stuff coming or what? But no, probably not. That's why the defense leaked it. There's nothing else there, literally. That Fani's case is crap. So he says, look, Fani, if I was going to leak something, it wouldn't be Sidney Powell or Jenna Ellis. It would be this. And this is a clip that he posted on his X account saying, I do want an attorney, from Ruby Freeman. Wonder why that might be. I don't know why she might want an attorney, curious. She's just an election poll worker, right? So they say here on November 14th, they also saw Harrison Floyd tweet about this. He said, or I would share that the officers who overheard the whole conversation thought there was a cover-up. And he says, I would tweet this one. I would just share that the officers who overheard the whole thing, saying that the other officer says she didn't feel comfortable talking to somebody, right? And you can go listen to the whole thing right on his X account, all 57 seconds about it. Oh, very curious. I wonder what she was going to say or what this cover-up was about. What were they doing? I don't know. Harrison Floyd certainly talking about it. You know who doesn't want him to talk about it? Oh yeah, Fani. So here we're going to look at another post from Harrison that Fani does definitely not want us to read. But it says here, the defendant tweeted the following about Ruby Freeman. Says, so if there is no protective order, here's the 911 call that shows. And now that I'm thinking about that, that might be the strongest charge that she has in this entire case, is like a new charge for something like that. Like, wait to hit him again on a process crime. Maybe that's where she's going. We'll see. So no threats were made, he says. So if there is no protective order, here's the 911 call, which is part of the public record. He says, no threats were made. Ruby Freeman wanted them to come back and to tell her what we could do for her. Ruby set up the meeting at the police station, not me. I did nothing wrong. So he's just proclaiming his innocence here. He's explaining himself in the court of public opinion, in the court where many Americans are observing this case. And Fani wants it protected under protective orders. She wants him now arrested for violating the terms of his release conditions. She wants Fani and Sidney not saying anything about any of this stuff because they're basically, gagged now from talking about the case. And he is basically doing the same thing Trump's doing, right? He's defending himself in the court of public opinion, just like Donald Trump is doing. This is a political prosecution against Donald Trump, who happens to be the leading political candidate, but this guy was highly involved in working on behalf of Trump. And he's also a victim of the umbrella of criminal prosecution. So now he's exercising his free speech to talk about these other people. And now they're trying to essentially throw him back in jail. Now, he is not the president, right? So this is going to go a little bit differently for him. But he's trying to make his case in the court of public opinion while they're trying to railroad him elsewhere. And maybe they'll charge him with another crime now that I'm thinking about it. But they say on November 4th, the defendant tweeted the following about Freeman. Why would my team leak Jenna Ellis and proffer videos when there's better stuff? Here, Fani, how about this? For instance, we could leave this one. We could leak this, that Ruby Freeman's job was the reconciliation of ballots. She wasn't even supposed to be on a scanner. Now, I think this stuff is more safe because he's just talking about the case. He's not actually like tagging Ruby Freeman on those. But the other things where he's tagging people, that's the thing that gives me a little bit of concern on that. Like he's actually tagging people, like it's actually direct communication. But here on Ruby's, right, he's not actually tagging her, and he's not tagging Jenna and Sidney. And here, Dan Scavino has not been charged. Jenna has taken a plea deal. So it's like a direct communication. Georgia Secretary of State, that one's a little bit hairy right there. So we'll see. Look, by the way, I am all in favor of free speech. I'm not trying to go that direction here. I'm just saying, what is Fani going to be doing? What's the next step here? She's going to say he violated his release conditions and is probably gathering evidence to charge him with theoretically another crime. And since the rest of her cases here, including Harrison's, are so dang weak, she's offering everybody diversion deals. That might actually be a safer case for her, honestly. Now, the defendant on November 14th did it again. Says here, DA Fani Willis doesn't want you to know the following. And this guy's just on a tear. Court of public opinion defending himself. Says federal agents knew and approved the meeting. No threats were mentioned. Ruby Freeman was provided options for help at her discretion. Hashtag Fulton County, hashtag fraud, hashtag Georgia, all the documents, all the videos on his X account. And you can also see the frequency is picking up, okay? November 14th and so on. So she's trying to shut him him up. He's just been going off. Now, I did not set up the meeting at the police station, says Harrison Floyd. Ruby Freeman asked the officers to arrange and facilitate the meeting. We did nothing wrong. He's defending himself in the court of public opinion, since they're trying to gag everybody else elsewhere. He shares his photo on his X account. It's actually a full minute video that you can follow him and watch at HW_Floyd on the X account. And he's got this photograph of a dog and an officer and other things taking place. He posted this, 8/12. Does this sound like Ruby Freeman is being pressured? Listen to it. Why would DA Fani Willis try to hide this from the public? Good question, Harrison. Very good question. Yeah, I think it's important to talk about these things. This is what Fani says. Now, as detailed, witness Ruby Freeman has been a frequent target of his intimidating communications, and count 31, he's charged with influencing witnesses in violation, which involves Ruby Freeman herself. And because of his intimidating communications, Ruby Freeman has been the subject of renewed threats and violence from third parties, right? We'll see what she does here. Now, as set forth, since his release from custody, defendant has engaged in a pattern of intimidation known towards co-defendants and witnesses. This is the same type of garbage language we hear from Trump. Sounds like Molly from Jack Smith's office or Jay Bratt. Communications about the facts to this case to known co-defendants and witnesses and the obstruction of the administration of justice in violation of this order. It says here, Harrison's actions demonstrate that he poses a significant threat of intimidating witnesses and otherwise obstructing justice, making him ineligible for bond, meaning he's got to go back into jail. Okay, no fines like Engeron gave to Trump or anything. Jail. Accordingly, the state requests that the court enter in an order revoking the bond that was previously granted to Harrison Floyd. Can't X from jail. Signed here personally by Fani Willis. Look at that one. Fani got off her fanny and signed that one, and that's a curious thing. So here's what they want. Here's the consent order. They say he was already on a $100,000 bond. He posted 10 of that, and here's what they signed this one back in August, right? And here's the release conditions. Shall not communicate in any way, directly or indirectly, about the facts of the case. So let's just say, like, it doesn't say he can't use social media. No act to intimidate any person known to him to be a co-defendant or witness. It's very broad, okay? So, like, there's a lot to interpret here. And so we'll see what the judge does about it. Now, the judge has scheduled a hearing on this and ordered him to be there, has ordered Harrison Floyd to actually physically be there, which is always a nerve-wracking experience when your client is potentially going back into custody. So we'll see what that looks like. Now, that hearing, I believe, is scheduled for next week so that Harrison Floyd has time to get there, but it will be an in-person order hearing, and then we'll see what the judge does with that order. We'll see if they throw him back in custody or not, or the judge issues a warning or gives him a little talking to or what, or maybe nothing. We'll see. But this is also what the judge has issued on the protective order. So we had a debate about the leaky footage. Leaky Fani and her leaky office has a leaky footage problem. And according to them, they said that we don't want the defense attorneys to continue to post this stuff all over the interweb so everybody can see what a garbage, terrible case we have. And so they've decided that they want a protective order. Now, yesterday, we heard that a defense attorney had already leaked these footage, has already been reviewed it and said there's nothing here and everybody should know it because the media was telling us that these were huge victories for Rico and Fani, and they're not. They were terrible. So here we see that the state requested an order. A lot of people on the defense agreed with the order. The media detests the order, and some criminal defendants did too because we want all of it to be public. But here's what the judge says. On September 27th, the state requested entry of a protective order. Then we got notice that they began negotiating about a joint protective order. 1 week later, Schaefer filed a second notice, said protective order impasse, and the court never got a proposal. When the court inquired about a protective order, they said that we're not yet ready for a ruling. Now, right, so the government kind of blamed the judge for not issuing a protective order at the outset, and the judge is backhanding them right now and saying, hold on a minute. Don't tell me that I didn't get an order even though you asked for one. I inquired about the matter in open court, and the state and council indicated they're not ready for a ruling. Now, you filed an emergency motion, and the defense responded. So we conducted a remote hearing that we listened to previously on this channel. The full video should be out. And several people did not appear, but everyone did. Now, intervening counsel, so he says what happened. These people consented to the entry of the order. Defendants Clark, Harrison Floyd, and Hampton, they opposed any order with various levels of strenuousness. Some did not appear, and intervening counsel for the media also voiced his objection. Now, having considered the dueling proposed orders, the law, the court finds the entry of a protective order concerning pretrial discovery is necessary. and justified by this case. They say in Georgia law, if there could be some harm, an order is appropriate, thus setting aside whether there is a substantial threat. He says, I've got some other concerns. He says, discovery is designed to avoid unnecessary surprise, and a party may attempt to delay and do things with disclosure, and we're going to have battles over whether there should be releases. Now, he says, borrowing from well-litigated principles at a higher level court, the court also notes that this does not offend the First Amendment. So it helps with the facilitation of the trial and the process. It's not a mandatory thing that everybody has unfettered access to it. And it also doesn't offend the First Amendment, which is what I was really looking for. It says, in addition, here, the proposed protective order exempts information gained from other sources and is more narrowly tailored than a blanket umbrella order that covers all discovery. So he feels safe under the law that he can do it. The likelihood of harm in this case is severe, as extensive media coverage guarantees broad dissemination of any disclosed discovery materials. And finally, the order is not indefinite and will expire. So with these in mind, we are entering the attached protective order proposed by Schaefer. Now, I think it's interesting because I would like to see those proffers. Now, I actually agree with him. Like, if we saw those proffers and more of that, I think it would make Fani's job harder to secure these plea deals. Or, I'm sorry, she would have more pressure to not secure the plea deals. Fani has cover right now because nobody knows what she's doing. If we all know what she's doing and the left starts seeing that these cases are weak as heck and they're not going to result in any actual convictions, and including Trump, they're going to start demanding some more pressure from her. She's like making these go away by just giving them diversion deals. So here is the order. It says the protective order does not apply to information or records that are publicly available. The purposes, sensitive materials shall mean anything that the state and their discovery produces to the defense in good faith. The state shall review its obligations. Anything that's sensitive shall be designated sensitive. If you think it is designated sensitive and it should not be, you've got 14 days to challenge that, and it applies to everybody in your offices. You can modify this protective order and so on. So, all right, I think it's basically limiting most of the disclosure, anything that's deemed sensitive. We're not going to see more plea proffers, unfortunately, is what I'm guessing. So the defense attorneys are not going to release it. Fani's not going to release it, and it just, figures. Now, we'll see if anybody appeals it or not, or whether they just live with it. I tend to think that they will. So we'll see what happens at the bond hearing, whether Judge McAfee puts Harrison Floyd back into custody or just gives him a little bit of a warning. I think it's probably going to be the latter, but we'll see. We'll be covering it, my friends. This case, the RICO case, all the other Trump trials. Be sure you are subscribed. Thank you for joining us. Thank you for checking out robertgovea.com, where you can access these PDF files, access the mind maps, sign up for our newsletter so you get the show segments delivered to your inbox so you never miss a thing. We'll be looking forward to seeing you right back here on the next one.